U.S. Supreme Court will decide later this year whether to overturn the constitutional protection for same-sex marriages nationwide. But with the new federal protections and a state constitutional ban on same-sex marriage, what would a repeal of that right mean for couples here in Michigan? 13 on Your Side political reporter Josh Albertus verifies.
Talk around same-sex marriage in the United States made new headlines this month after the U.S. Supreme Court was asked to overturn its landmark 2015 ruling in Obergefell v. Hodges that guaranteed same-sex marriage nationwide. The possibility of Obergefell being overturned has had many asking what it would mean for their marriages, especially in a state like Michigan, where the state constitution may conflict with new federal law. So what would a post-Obergefell America mean for same-sex couples in Michigan? Let's verify. Our sources include the Michigan Constitution, the Respect for Marriage Act passed by Congress in 2022, and Tracy Brain, Associate Dean at Cooley Law School. Following a statewide vote in 2004, Michigan's constitution has included a small but consequential clause saying that, quote, the union of one man and one woman in marriage shall be the only agreement recognized as a marriage or similar union for any purpose. So if Obergefell was overturned and the issue sent back to the states, Michigan would not be performing same-sex marriages anymore. But that doesn't necessarily mean people who live here wouldn't be able to have their marriage rights recognized here. That's where federal law comes in.
It does require the U.S. federal government and all U.S. states, right, to recognize the validity of same-sex marriage.
The Respect for Marriage Act was passed by Congress 3 years ago and requires the federal government and all states to recognize the rights of marriages performed where it is legal. So if I lived in Michigan, for example, but got married in a state like New York and came back, Michigan would still have to respect that marriage. But what about pre-existing marriages?
The act is pretty clear, right, that at the federal level and right at the state level, existing marriages should be respected, right, across the 50 states and even into the territories.
When determining if a marriage is valid in a state, the act says only the law of the state at the time the marriage was entered can be considered. It also should be mentioned that the Supreme Court isn't yet guaranteed to hear the case at all. That decision will be made later this year. With your Verify, I'm Josh Albertus.